Okay, this afternoon we are meeting with Professor Valerie Epps, and actually Valerie was my professor of public international law many moons ago. So to start off today's interview, I just asked Valerie to introduce herself.
Hello, my name is Valerie Epps, and I teach international law at Suffolk University Law School. And over the years I've taught a number of subjects, but have basically concentrated in the public international law area, and I've also made a specialty of the laws of war.
Okay. So maybe to kick off today's interview, we could start with the origins of international law, public international law in particular. I've read various claims to persons who kicked off international law. Some attribute it to Grotius, or the works of Erasmus, or the School of Salamanca. Amongst the true experts, is there any kind of consensus about where and when international law really kicked off?
Well, some people trace it back to the Greek city-states. The fact of the matter is, once you get some sort of a state system emerging, states have to think of a way about how they will interact with each other in the legal arena. And so, I mean, it depends when you say the rise of statehood. The great Dutch jurist Hugo Grotius was certainly writing about the notion of legal relationships between sovereign states and so on. And throughout, certainly 16th, 17th, 18th, 19th century, in the developed world, you began to get codes of operating procedures. And of course, since time immemorial, different clans and tribes have entered into agreements with each other. Those agreements we now call treaties, and we have a big treaty on the law of treaties, the Vienna Convention on the law of treaties. But the notion about how one separate entity interacted with another entity that it saw as the other has gone on for thousands of years. And of course, when you come to the area of warfare, a sort of notion about what are the rules of warfare and have emanated from a number of different sources. The whole theory of the just war, which every single religion has had a theory of a just war. It basically depended upon the religion and depended upon the aims of a particular entity, but they've all had a notion of when it is acceptable to go to war, and to a lesser extent what the rules of conflict are once you're engaged in armed conflict. So in those areas we can say many thousands of years.
I mean, if we just look at the past few centuries, an interesting question is the role of culture in all of this. So if you had European explorers going to other areas, they may have had preconceived notions of what a state or society should be like. How did that play into relations between groups?
Well, of course, the rise of empires and colonialism played a major part in shaping the system of government that we have. Eventually, of course, colonialism gets rejected beginning in the 1940s, really, with India declaring independence and then rapidly moving forward then. Although, of course, we should say the Latin American countries in an earlier era declared independence from Spain and Portugal and so on. But the whole idea that if you were a powerful nation, you had the right to go and wage wars and grab land and declare it was yours and rule it, was a philosophy that held sway for, well, the Romans certainly did it, and the Greeks did it, but coming down to the more modern times, you have the Dutch doing it, the Germans doing it, the French doing it, the British doing it, and there was no law that said you couldn't do this. It was might is right. I'm going to go there, I'm going to declare it, it's mine, you're going to be ruled by my rules. And it isn't until the middle of the 20th century where that becomes rejected, both with respect to you cannot wage war just because you feel like it and just because it meets your policy. That gets cut out by the UN Charter in 1945, but not till 1945. And then we had a great policy change, really, where the notion that people should be able to rule themselves and not be ruled by an alien power came into being, and rapidly, so that by the moved through virtually all of the non-independent countries. So by the late 1970s, almost every state that had been a colony was no longer a colony, unless it specifically chose to remain as a colony, which some areas have done. If you take, for example, Bermuda. Bermuda's had, which is a crown colony of Britain, it's had a number of referenda asking it itself whether it wishes to become independent, and so far it's rejected independence. The Falkland Islands, of course, was the same. They've had a referenda of that. Of course, Argentina claims the Falkland Islands, as the British do, but the British said, oh, go on, have some referenda. 98% of them vote to remain as British. Probably because they're a very remote and small area and probably just couldn't survive without a bigger power behind them.
That's a good segue to another question, which is the bases for legitimacy of the rules of international law. You touched upon examples of consent, whether formal, such as treaties, or informal, and then a whole period where might was right. And I guess that one way to think about that is one culture feeling itself more advanced than another, and therefore having the right to impose, in their minds perhaps in a beneficial way, their more sophisticated culture on the recipient society.
Right. Well, as you can probably tell, I grew up in England. And I am old enough to remember my grandparents' generation, who went out and administered various lands for the British Empire. And their view of it was that they were bringing civilization to peoples who didn't have civilization. That was their view. They were also bringing religion. In the case of the British Empire, it was the Christian religion, but of course we've had other empires like the Turkish Empire, an Islamic empire, but an Islamic, actually the Turks were interesting. They were not so insistent upon Islam being the religion of the areas that they conquered. Whereas, of course, the 19th century in particular, muscular Christianity was really part and parcel of all of the, I think, well, certainly of the Dutch Empire and the British Empire, to some extent, the German and the French empires too. So they perceived it as beneficial, as you say. And they were not evil people. Many were not evil people. Some were, of course, in any society. There's evil people. But as time went by, people said, we want to rule ourselves. And of course, it was Gandhi's great movement for independence of India. And of course the irony is that of course India had a highly developed civilization before the British did. And actually I've read some interesting books which basically say that at the time when the British went to India, India had at least as high, if not higher, development of literacy, music, mathematics, science, and everything else. And the only thing it didn't have was guns, or as sophisticated guns as the British. So that the notion of the Indians being a nation that needed civilizing in the light of subsequent what we know was ridiculous.
Yeah. Actually, I just came back from India a couple of weeks ago, and it's an interesting example of, and it ties into another question, which is the relationship of the law which a colonizer or an occupier imposes on a recipient society. It's not always 100%. So, for example, in India, the British, and in Africa, they also had indigenous courts with indigenous judges and a form of self-rule within communities. Not across the board, but maybe you could touch upon the relationship between law, which was allowed to stay local, in those situations where there was an empire or a colonizer.
Well, of course, with India, of course, you had the princely states, of which there were a number, and that remained what you might call semi-independent throughout the time that Britain ruled India. So that certainly within the princely states, you had a large measure of local rule in one way or another. But ultimately, I certainly think the British were interested in bringing in the British legal system, as well as British education system for some, by no means all, British transportation system, and of course, as most people note, India has a very extensive train system, most of which was put in by the British.
Yep.
And here we are, 1947 to 2015, and not much has changed. It's now just beginning to change.
Yeah.
But certainly in many ways, in 1947, when the British left, India actually had what for mid-20th century was really quite a sophisticated transportation system that had been put in by the British, basically. I mean, when I say put in by the British, the labour, of course, was supplied by India itself.
Yeah.
The engineering was basically supplied by the British. So, you know, not all of it was bad, and some of it was quite useful. I mean, the British legal system. Bad laws as such, just like South Africa during apartheid period, the laws were bad. But interestingly enough, just as in South Africa, it was a fairly uncorrupt system, and which, you know, has been different. Many developing countries have a tremendous problem with a corrupt legal system. So you have bad laws that call for discrimination, but a sort of impartial application of those discriminatory laws.
Yeah.
It's a bit of an irony.
And do you think an approach which allows some element of self-rule or family law or certain pockets of local law, does that increase the chance of the rule being seen as more legitimate?
Well, let's put this into a fairly modern context. As you know, there was a terrible genocide in Rwanda in 1994. Hutu against Tutsi largely, but some Tutsi against Hutu as well. In the wake of that terrible genocide, when it was over, the question is what's going to happen. The Security Council, on request from Rwanda and other African nations, created the International Tribunal for Rwanda. But it was always known that that court would basically be trying the big-time leaders of the genocide. Yeah. And in that country, after the genocide finished, a very large proportion of the population had either been a victim of the violence or perpetrated the violence or both. Yeah. So you had hundreds of thousands of potential criminals. Yeah. And there was no way that the International Criminal Court could deal with that. So what happened in the end was the International Criminal Court has dealt with the big-time criminals. I think there's 1 or 2 still outstanding cases. The local Rwandan courts then took up serious crimes, but had hundreds of thousands of cases pending, and the national court simply couldn't cope with them. Yeah. So what they did in the end was to go back to the traditional method of resolving disputes, I can never say it properly, the Chakacha system, which that word means sitting in the grass. And the reason that it means that is that the traditional way was that there were some elders who were respected, and people sat down and discussed a dispute. Now, the way it was finally set up to incorporate into the national and international was that judges were actually elected at the local level by the Rwandan people, and then they were obviously respected elders. Yeah. And then they essentially administered the customary law based upon Rwandan customary rules. And although there's been a lot of criticism of those courts and how they operated, because they certainly don't have things like you have a right to remain silent, you have a right to counsel, you can cross-examine witnesses. They don't have anything like that. Yeah. Nonetheless, I think they probably brought a fair measure of a sense of the story being recorded for the victims, and to some extent quite a number of those who were accused agreed that they had violated the law and were remorseful, and were given oftentimes judgments that that required forms of community service and forms of paying back to the victims. So that's an example, I think, of where using customary law along with a more what we might say enacted form of law and the international law, using it all in combination, has been quite successful.
Yeah. I mean, as you point out, the sheer numbers would have made it difficult to
impossible.
Apply a Western approach, say, to prosecuting. And I guess the added benefit of this approach is you may have a better chance at reconciliation for this face-to-face.
Yes, I mean, I think all of the systems of dispute resolution that come about in the wake of civil wars or protracted violence of some sort, they're all trying to say, how can we move forward in the light of these terrible atrocities where we know a large percentage of the population has been involved in them in some way or another? How could... do we want to give everybody amnesty? Do we want to prosecute everybody? What do we want to do in terms of making sure that the history is known. And so, of course, now over 40 countries that have suffered from high-level atrocities have set up Truth and Reconciliation Commissions.
Mm-hmm.
And probably the best known of them is the South African one.
Yeah.
And they all have slightly different powers. So you can't say, oh, they get to grant everybody amnesty if you confess, because each one of them has different sorts of powers granted by the legislature.
Mm-hmm.
But they still all have the same notion that they want the history to be known.
Mm-hmm.
They don't want it swept under the rug.
Yeah.
They want reconciliation to take place between warring or violent factions. They want to be able to move forward rather than endlessly being bogged down in determining who was guilty and who was not. But at the same time, they want measure of justice too for victims.
One of the places I've traveled is Cambodia, and they had their own terrible history, and but it seems to have a different approach there, where you have some UN involvement, but it's really I think five or six of the main leaders were subject to prosecution, but they didn't seem to go to the great extent, say as in Rwanda, of covering the rest of the population. What's the story behind that?
Well, of course, with the Cambodian courts, first of all, it's taken a very long time to get this set up. And we have had now, I'd have to look it up, but we've had, I think it's 3 or 4 people convicted. I've got it right here in the chapter sitting on my desk that I finished up last week, but in any event. And I just picked up the fact that 2 more people, I think, are going to be prosecuted. But there's been a great hesitation, perhaps because of the when you've been through something as devastating as the Khmer Rouge's rule, where between 800,000, I think, and 1 million people were killed or starved to death. And when you're now, what are we now, 20 years on from there, there is a great reluctance to dig it all up again, to relive it again. But certainly they have what we would call a quasi-international court, where they have assistance from the UN, they have certainly international standards that apply to the criminal victim, to the defendants, and so on. But there's been considerably more reluctance in Cambodia than in many places where you've had the hybrid courts, as we call them, part international, part national setup.
Yeah, it's interesting to note that this is a phenomenon that happened in the West as well. If we look at places like Spain, Spain hasn't had a UN tribunal, but recently they've had some domestic legislation, historical memory laws and such, where they are revisiting their past. And again, maybe it's to your point, you need to wait a certain period till the willingness is there after such a tragedy. But it's difficult to extricate the justice and legal dimension from the political dimension.
Yes. And I suppose one of the great questions for the Chinese will be eventually. Mao has been held in ultimate respect. But we're beginning to see what some would call revisionist history. Nevertheless, sort of hundreds of thousands of people died and were starved to death in the Cultural Revolution. And I taught in China during 2006, at a university in Shanghai. And when I first got there, I wanted to ask people about the Cultural Revolution, but I knew that I couldn't because I picked up that it was too painful. Eventually, when I'd been there nearly 6 months and made some good friends, I began very tentatively asking about the Cultural Revolution and how they'd gotten on. And eventually I started getting people telling me how terrible it was for them and their families. And when they told the tale, it was clearly traumatic for them. So whether that will ever happen in China will be interesting.
If we could back up a step and just spend a little time on the concept of a nation state and how international law defines when a state arises. I still remember back to our course and the Henkins book and the various criteria, but maybe we could just run through how international law treats what we consider a state.
All right. Well, as you remember, there's a traditional definition that is given in international law of a state, which actually comes out of an old treaty, the Montevideo Convention, which talks about needing a defined territory, a population, an ability to enter into international relations with other states, and of course that requires some form of a government. Now, those are what we call the objective criteria. But the interesting thing about statehood is that although it has a legal dimension, and it certainly has a legal dimension, it also has a political dimension. And what we are, so that, for example, when you have a civil war in Ethiopia, which eventually, after much bloodshed, splits into two states, Eritrea and Ethiopia. At what point did Eritrea become a state, you ask, or anybody might ask? And it's hard to say when they became a state. Did they have a right to separate from Ethiopia? No, not really. But they fought a war, many thousands of people died, they declared they were going to be independent, they had a government, and finally the world said, we're going to recognize Eritrea. And so Eritrea becomes a state member of the United Nations and so on. Now, what we're beginning to see in the developed world is something that is a new phenomenon and is not yet played out. We've begun to see some states that have referenda on secession, on breaking up from the state. And of course the most recent one perhaps is Scotland, where with the British government's approval, people in Scotland were allowed to vote whether they wished to become independent or remain part of the United Kingdom. And they voted to remain part of the United Kingdom. But if they had voted, a majority had voted to become independent, then by some means or another, over a period of time, they would have become independent. They would have had to work out with the British government all sorts of things like what percentage of the national debt were they going to take on? How were they going to deal with the armed forces? What about the currency? I mean, there's a myriad of issues that have to be worked out after that, but no doubt it would have happened. Same might have been true with Quebec. Quebec had a referenda, rejected it, but if they had accepted it, then in fact it would have had to be worked out some way. And actually, of course, I suspect you know this, there's a wonderful Canadian Supreme Court case, what we would call an advisory opinion, they call a reference opinion, where they were asked whether under national law and also under international law, whether if Quebec declared itself independence, whether that would conform with Canadian law, whether it would conform with international law. The court actually found that it would not, under the present circumstances. It wouldn't conform with Canadian law or international law. But the court then asked itself a very interesting question. It said, well, let's suppose that even though it doesn't comply with Canadian law or international law, nonetheless, Quebec did declare independence. What would happen then? What would the law do then? And the court talks about what it calls the effectivity principle, which basically, a very wise person who wrote the opinion said, the law has to always catch up with reality. It can't bury its head in the sand forever. It's got to accept that if you've got this entity that's operating as a state, sooner or later law will catch up and recognize it as a state. Although, of course, we do have a number of enclaves, we call them, that are operating independently, but where the world hasn't recognized them, like Nagorno-Karabakh, for example, and so on. So there's this political element in there as well.
Yeah, Scotland was an interesting example because it triggered a whole lot of questions about within the European Union. What happens with the membership? Is it automatically transferred? Do they have to start again? Et cetera, et cetera. So I think those questions are still open.
Yes, I think they are too.
You mentioned the one of the requirements of permanent population. And in the textbook, the example given was, there's no numbers given, but even the Vatican is generally recognized as a state, even though I think it has 200 citizens.
Right.
But it doesn't sound like there's any minimum requirement. One of the places I visited for this series was Malta, which used to be run by the Knights of the Order of St. John, which these days I think is down to less than 10 citizens. It's an interesting question whether you reach a point where you say you can't seriously consider this a state with 2 to 5 people.
Well, interestingly enough, the issue of micro-states and whether they could really be states used to be a great issue in international law, I would say, up through the 60s into the early 70s. You could find articles written about just that question. Then people began to sort of either forget about the issue or think it wasn't relevant, and time went on. So you've always had a number of small states, both geographically and in terms of numbers, that are quite successful, such as Luxembourg, for example, Liechtenstein, and so forth and so on. And finally, people said, "Oh, well, if you want to operate separately," so that now I think I'm right in saying the smallest nation that's a member of the UN is Nauru, and don't hold me to this, but I think they've only got 12 to 15,000 people, something like that. Whatever the number is, it's very, very small. When you come to the Vatican and the Knights of Malta, yes, they're sort of teetering on the edge of being something that we recognize as a state, but they're not really the same as a state. So oftentimes we pose for students the question about whether entities such as the Vatican qualify as states or not, and if not, why not, and so forth and so on. They're not really quite the same, although they have diplomatic missions and so forth and so on.
One of the other requirements that you mentioned is this capacity to engage in relations with other states. But that doesn't mean necessarily that they need to engage other states, does
Well,
it?
yes and no. And also, even when you've got the capacity, if nobody will have anything to do with you, it's not going to work. I mean, we saw that with when the apartheid government of South Africa decided to create these so-called independent Bantustans. They started creating these independent black what were they called?
Statelets or something?
State. In any event, they issued them passports and so forth and so on. Nobody would recognize them. Everybody said, that's apartheid, we don't like it, we're not going to recognize them. And after a few years, they sort of went out of existence, became part of South Africa again. And then, of course, there was the uprising in South Africa. Finally, of course, in the 1990s, they have an open franchise, and Nelson Mandela becomes the first president of South Africa. So even though there was capacity to enter into relations, even though there was a sort of a government, perhaps a better example of that is White Rhodesia. In the era of Ian Smith's government in the mid-1960s. Now, there's no doubt about it. It had a defined territory, it had a permanent population, it had a government, actually, for the time, quite a well-run government, as long as you don't mind unequal laws for blacks and whites. And it certainly had the capacity to enter into relations. But the tide was against apartheid. And when Smith requested independence from England, which a normal colony by that time would have been granted no problem, the irony was, of course, that Britain turns around and says, no, we're not giving you independence because you're operating an apartheid regime. Even though, as we all know, the British, who had run Rhodesia forever, had never previously objected to distinct treatment of blacks and whites. So there you clearly had a government, you had all the criteria, but the rest of the world essentially said, nope, we're not going to do it. And of course, eventually the white government was overthrown and black government came in. That's had a number of problems, of course.
It's probably just a hypothetical question, but say there was a group of people that tended towards isolationism, and they came together and figured that the world's going to hell, we want nothing to do with it, let's set up our own state, and it's better if we just are self-sufficient and don't have anything to do with anyone else. Would that be a feasible state under international law if they wanted, if it was their choice?
I would say yes. I mean, if we go historically, that was Japan up to until the 19th century. And in some ways, you could say it was North Korea. Certainly there's, North Korea does have relations with China and with Russia to some extent. But it's nevertheless the hermit nation remaining. And certainly in this day and age, of course, everybody wants communications, everybody wants electricity, everybody wants to be able to travel. At least that's what we say. But if there was a nation that could be self-sufficient and so forth and so on and chose to do that, that, I think, would be their choice. You know, it's you want to behave that way. In other words, the requirement of actually having relations with other nations
you might have to revisit that.
Is not a requirement. It's really much more that if you wanted it, you could have it.
Sticking with recognition for a minute, you can kind of understand why that's important. What's sometimes surprising is the impact, say, of derecognition, or when things change on one side of the equation. If we look at the example of the United States and Taiwan, so up to a point in time, they were recognized as the legitimate government of China. Then that changed because of a foreign policy change of the U.S. How does that impact their status as a state?
Well, Taiwan is a very interesting example, of course. What's interesting about Taiwan is that both the Taiwanese government and the Beijing government believe that there is but one China.
Mm.
And the issue for both of them is, where's the true government? Not whether there's a one China or not, but where's the true government?
Yeah.
Now, in reality, what we know is that the Taiwanese government is running Taiwan, and it's not being run by Beijing, and the Beijing government is running the rest of China.
Yeah.
But neither side is as yet willing to say, okay, this has gone on long enough. Taiwan will just have to be a separate nation, and China will be the rest of it. Although, as we constantly hear, the younger generation in Taiwan is largely of that view, that they basically say, come on, forget this one China, let's just say we're an independent nation, and we'll go the route of secession and declaring ourselves to be independent. Of course, if they ever did that, Beijing China would essentially pull out all the cudgels to essentially prevent that by using economic persuasion and so forth and so on. So, but I have often thought that if the two sides ever have any hope of unifying, they ought to get on and do it, because you're essentially losing those leaders who remember a unified China and want a unified China. And when you've lost that generation, the next generation is not going to have as much interest in it. But of course, the world did the same thing. It came to the conclusion that, most of China was in fact being ruled from Beijing. Now you can bury your head in the sand and pretend it isn't so, but it is so. And of course, right at the moment, we have Cuba-US relations undergoing very major changes. And again, it wasn't that the United States said there is no Cuba. The United States simply said, we don't like your policies and we're not going to have anything to do with you and we're not going to trade with you. Now, whether that was the right policy or not is a different question. But it wasn't that we were saying Cuba doesn't exist. So we knew that we couldn't fly over their airspace, although there were some private groups such as Brothers to the Rescue that did and paid the price for it. So the United States was clear that Cuba is a state. It's just up until now, like this minute, they've been saying, no, we don't have any relations with you. We're not going to trade with you. But all that is about to change, I think.
A very interesting example. Traveling around Europe, there's been some more almost comical examples of very small communities declaring themselves as separate from the country where they find themselves. I don't know if if you're familiar with the neighborhood in Copenhagen called Christiania. It started as kind of a hippie commune in the 70s, and they kind of said, well, this is our community. They took over some empty buildings and basically set up their own society. And they were, it became known for a tolerant view towards drug use, but it was kind of tolerated by broader Danish society. But now, there've been court cases about whether they're really on their own or whether they're taking over this part of the city was legal, whether they have any squatters' rights. So it's something that's gone all the way to the Danish Supreme Court. But in theory, if a group, however big, is able to meet some of these secession requirements, how would they become recognized as their own unit, even within the
Well,
state?
I think it's only through the act of secession. I think the notion if you set yourself up within a state
Yeah.
and don't say we're independent from you, if you
Yeah.
say, oh, well, we're within the state and so on, well, the state's going to have the power to tax you, it's going to have the power to say you've got to meet certain rules with respect to employment and minimum wages and
Yeah.
whether children go to school
Yeah.
and whether you can have multiple wives or husbands. All of those rules that are made by central law-making authorities are going to apply to you whether you like it or not, unless you go the route of secession and unless you're successful.
Yeah.
And basically, although throughout history we've had peaceful separations, most secession comes about through war.
Yeah.
And it's often very bloody because it's a civil war, and civil wars are the most bloody.
Yeah.
But sometimes we do get peaceful separations. I mean, the Czechoslovakia split into two, and that was peaceful.
Yeah.
Earlier, of course, Sweden and Norway in 1905 separated.
Yeah.
Although my Swedish friends tell me that there was nearly a war, but it didn't actually happen. So you can have peaceful separations.
Yeah.
But of course, those are not like the examples that you have given in Denmark, because they are where at various times in history they had been separate and then they were under different crowns and so on.
Right.
But they've maintained a certain level of distinction in terms sometimes of language, sometimes religion, so forth and so on. So it's a little bit different from a group taking over part of a city and saying we're it. You know?
So we've cut a lot of ground of how public or international law evolved and developed. How about the institutional framework? Most people are familiar with the UN, but I've been to The Hague, and there you can visit the International Court of Justice, and it had its predecessor. How did that kind of institutional framework get started?
Well, this is interesting. I suppose you have to start with the League of Nations, 1920, after World War I. But of course that was a small number of developed states that got together and tried to make some sort of international institutions, and did for a while.
Yeah.
Then of course we got World War II, the League collapses. After World War II, then you have the establishment of the United Nations. And the UN Charter and various, first of all, institutions, the organs of the UN, including the International Court of Justice that sits in The Hague and has the power to resolve legal disputes between states, not between individuals, but only when states consent to its jurisdiction. There was, when the Charter was being drafted, it was hoped by many that that court would have compulsory jurisdiction over states that were members of the UN. But in the end, of course, it was the powerful states that defeated that, so that now you have to consent to the court's jurisdiction. You can consent in a number of different ways.
Yeah.
But what's happened, I think, really at a very fast pace since about the 1980s is the proliferation of dispute settlement mechanisms. And there's all sorts of ways to create them. Let's talk about one way, such as you create a treaty. Take the Law of the Sea Treaty, 1982.
Yeah.
That treaty creates a court, the Law of the Sea Tribunal, that sits in The Hague. If you become a party to the treaty, you don't necessarily have to submit to the tribunal in The Hague. But actually under that treaty, there is a mandatory dispute settlement mechanism.
Mm-hmm.
You have to choose from certain types of dispute settlement mechanisms. You can choose the Law of the Sea Tribunal, you can choose the International Court of Justice, you can choose various forms of international arbitration, but you have to choose one.
Mm.
So that's a mechanism whereby you say, okay, actually it's a wonderfully successful mechanism. Before we had the Law of the Sea Treaty, there were in fact 4 Geneva Conventions relating to the Law of the Sea that had received quite respectable numbers of ratifications, but largely from developed states. But there were a lot of other areas that were not covered.
Mm-hmm.
And so people got together, they write this vast treaty with close to 400 articles and goodness knows how many annexes, and also recognize that there are going to be disputes that arise under the treaty. So how are we going to resolve these? We create a court, but we'll also give you some other choices about how to do it. So that's one example of how you create dispute settlement mechanisms.
Yeah.
Now, what we were talking about before has also, we were talking about truth and reconciliation commissions. And as I said, more than 40 of those have now existed. The notion of doing a quasi-national international court, we've got a whole list of those now.
Yeah.
Actual creation of international courts, first for former Yugoslavia, then for Rwanda, and now again through treaty, not by the Security Council as such. We now have the International Criminal Court.
Yeah.
That's created by treaty. States get together, they decide that, hey, we got some problems here in the world where the big-time criminals never seem to get prosecuted in national courts. What are we going to do about it? We're going to create an international criminal court. You create it. And on the private international side, of course, there's been a whole development, particularly through the World Trade Organization, of dispute settlement.
Yeah.
And you sign on to that, you sign on to a dispute settlement mechanism, and then you... What's happened, of course, is that particularly since the middle of the 20th century, particularly since the 1980s, the number of international transactions between people, between corporations, between other entities, between states has expanded exponentially. And whenever that happens, you need to have dispute settlement mechanisms. So there are thousands of international dispute settlement mechanisms now that are available, literally.
I mean, one of the ones that was really prevalent early on was the International Court of Justice. And as you mentioned, a nation would have to agree or consent to the jurisdiction. There was an interesting case which we covered in our class, Norway against Denmark, in relation to claims to Greenland.
Yes.
And going through that case, before I visited Greenland, it was interesting to see how important the documentation of the history of settlements played in that decision. And a cynic might even say, the one who had the better record keeping came out better. But how thinking about that case, how does international law, and the ICJ in particular, handle competing claims like that to the same territory?
All right. Let's get to that case down the road a little bit, but let me talk about the ICJ. The International Court of Justice, as we said, was set up by the UN Charter in 1945 and really came into existence perhaps 1946, or had its first case, I think. Now, from 1945 to about 1985, 1990, I think I'm right in saying that its average caseload was 1.2 cases a year. And as we said before, it can only take cases between sovereign states when they have consented to the court's jurisdiction.
Yeah.
So what was happening during that period? Well, States didn't quite know what this institution was. They weren't too sure of the law that it was being applied. Many of the developing states viewed it as a developed states white person's court, applying developed state law for their benefit.
Yeah.
And there was a great level of skepticism on the part of the developing states with respect to the institution of the International Court of Justice. Finally, the ICJ had a case in which Nicaragua sued the United States. And it basically argued that the United States had violated the UN Charter by engaging in various war activities in and against Nicaragua. And Nicaragua won. It's a hotly contested case. And I think it's fair to say the developed world was very surprised that Nicaragua won. Nicaragua, of course, is, I think it's the poorest country in the Western Hemisphere. Here it was up against the most powerful nation. And it wins. And ever since that Nicaragua case, 1994, no, I haven't got the date right, 86. Ever since that case, the developed world said, oh, maybe we could use this court. If you look at the court now, and you look at the docket, you have cases from Asia, from Africa, from Oceania, from all over.
So that was a real turning point.
A real turning point, not only in terms of the range of states that now use the court to settle disputes, but the number, huge number now being settled by the court. Also the Permanent Court of Arbitration, which also sits in The Hague. That was a case that was a institution which was on in paper. When it was first created, it had a good number of cases, and then it sort of went moribund for a good number of decades. Now again, if you go to the docket for the Permanent Court of Arbitration, you've got a whole list of different states from all over the world using that institution to settle their international disputes. So I think the international institutions, including those set up by the UN Charter, have risen dramatically in their credibility and now are being used very widely throughout the world. States are willing to use them. Because the thing you have to remember about deciding to go to an international court to have a legal dispute settled is you've got to be prepared to lose. If you're not prepared to lose, you're not going to use it. And of course, the United States was pretty upset at losing the Nicaragua case and actually withdrew from the jurisdiction of the court after that case. You've got to be prepared to lose.
Yeah. And getting back to the case about...
I'm sorry. Yeah. Yes, getting back to that case. That, of course, was a land dispute case. And it had to do with, you're right, that... So we're talking about a big island, Greenland. And we're talking about whether... What had happened in that case, of course, was that Denmark, since about the 9th century, had had settlements from time to time in the western part of Greenland. There was no settlement in the eastern part of Greenland. And in 1931, a Norwegian expedition turns up, and then I think again in 1930, 31, 2 years from now, what do they find in eastern Greenland? Nothing. Now there's a doctrine, as you know, called terra nullius, which means that if a land has not been claimed by any people, then you can go there and claim it. So the Norwegians said, this is our land, because nobody's here and nobody's been here. Now, ultimately, Denmark sustained its claim, by virtue of a number of things. One is that it had these settlements from time to time, and that was well documented on western area. They had done various other things, like they'd mapped the whole of the island. They had put into existence, as I recall, certain edicts, such as if you want a fishing license off Greenland, you have to apply to us, and so forth, so on, of that nature. So they had some documentation. They had also been quite industrious about going round whenever there was a treaty that Denmark was going to enter into. It would require other states that were going to sign this treaty, that had nothing to do with Greenland, to essentially say, we signed this treaty, and by the way, we recognise that Denmark has the right to Greenland. So they'd gotten recognition of their ownership rights from a number of other states. But in the end, of course, there was also the Norwegian statement in diplomatic correspondence and in speech that they were willing to recognize Denmark's claim to Greenland, provided that Denmark would recognize Norway's claim to Spitsbergen. So it was a tit for tat, and essentially the court said that was a binding statement from the foreign minister, Ilhen, who had said this, that he was, and that was binding on Norway.
Now, Greenland itself has been on a bit of a journey, so they're still connected to Denmark, but not as closely as before. I think the main link now is more of a financial one, and they get support from Denmark in terms of administrative resources, government resources, but...
Are they Danish citizens?
I'm not sure.
I mean, can they go and live and work anywhere in the EU?
I doubt it, because I think they began actually as part of the EU through Denmark in '73, but then they had an act on self-government with a clause that has some limitations. For as long as Denmark is providing funding, they're not joined at the hip, but they're still somewhat joined. But now the interesting thing with global warming is Greenland potentially is sitting on incredible natural resources. They may not need any financial support from Denmark quite soon. So that, if that is set in motion, they quite possibly could become fully independent, meeting all the requirements that we went through at the beginning of this talk. Maybe not so good for the rest of the world. We'll have to see.
Actually, of course, global warming, which everybody, I think virtually everybody recognises as a very major problem, comes into play, of course, in the area of states now. Because, you know, there's a number of small island states that are thoroughly expecting to be submerged. And there are certain political parties in those countries that one of their political platforms has been, vote for me because I can work out a deal with state X to let us all go and live there if and when we get totally flooded out. Whereas my opponent, he doesn't have any diplomatic skills. He's never going to get you a place to live, and so forth and so on. I mean, this is real time for a number of low-lying island states. Although, having said that, I always think of the Dutch. I mean, at least half of the land in Holland is reclaimed land below sea level, and yet they seem to manage to do it. So whether you could do that in a small island in the middle of the sea, I don't know. I mean, Holland is attached to a big piece of land.
Right, and they have incredible engineering to save that part too, which the islands don't have the benefit of. But, but it does raise another couple questions, and then we can wrap up. One is tied to the Arctic, but a few years back the Russians sent a craft down into the ocean and put a flag on the ocean floor, and is using that as a claim, I believe, under the law of the sea to certain parts of the Arctic Circle. What is the applicable law in relation to the Arctic, and where do you think that is heading?
Well, the Arctic is interesting in the sense that the Antarctic, of course, there is a treaty relating to the Antarctic which basically says, okay, we know some people have got claims to portions of Antarctica, but we've set up this treaty, and whatever you do from this moment onwards, when the treaty was entered into, you can't increase your claim. And there are things that with the Antarctic Treaty it says Antarctica must be used for peaceful purposes and so forth and so on. With the Arctic, of course, it's a bit different in the sense that there are a good number of claims and there are a number of overlapping claims.
Yeah.
And there are different ways of making a claim in terms of the most usual one is what's known as the sector system. So you've got the globe, so your country goes from here to here on the globe, and then you draw a sector up to the North Pole, and you claim everything that's in there. This is not entirely accepted by people. However, what has been happening is that there has been a charter drawn up with a place called something like Ilusia. I'm not pronouncing it correctly, and I'm not remembering it correctly, which is the Arctic Council, set up the Arctic Council.
Yeah.
And it's made up of representatives from all the countries that claim to have rights in the Arctic.
Yeah.
And at the moment, the Arctic Council, which has only just been set up in the last few years, doesn't have a whole lot of power, but it's like everything else that starts out as an institution. Over time, it probably will have some powers, because everybody knows the time is coming when you've got the Northwest Passage, you've got claims that are going to be made, claims are going to have to be sorted out, and so forth and so on. So we're just beginning to see the creation of some institutions that may be able to resolve those claims. And what you'd like to see is all of those nations getting together and saying, hey, come on, we need some cooperative deal here, whereby we all, and perhaps even humanity generally, gets to benefit from this. I'm not sure we're going to get the humanity generally benefiting, but we might get a sort of cooperative approach, or even an approach whereby, okay, all these nations have claims, okay, can we agree that you're going to have 12% and you're going to have 24% and something of that nature? So it's early days, but it's coming fast and it's going to have to be resolved. And this council that now I think will be the institution that, if anything happens, will be the one that resolves it.
Some alternative to military conflict.
Yes, I mean, you always have to say, so what's the alternative? If I don't use a dispute, a peaceful dispute settlement mechanism, what am I going to do? So,
well, Valerie, we've covered a lot of ground and ended up at the top of the globe. So I just want to thank you for spending some time with us today. That was great, and thanks again.
Thank you. You always ask most interesting questions. Thank you.
Thanks.